Okay, into the emergency law measures, being just mindful of our time. We have 2 more laws to get through. I think the chat function works really well. Oh, we have hands up.
Yeah.
Hi, sorry.
Go for it.
Okay, thanks. I just had a couple questions. I think if you look at section 3.2, I think you'll have to just review the wording because there's something missing. It says, you know, a person who has been directed either orally or in writing to leave the premises or stop engaging in an activity does not leave the premises as applicable as soon as practicable after receiving the direction, or re-enters the premises of Ganisadage, or resumes the activity on or in the premises of Ganisadage land as applicable. And then we don't know what the intent is. It's like there's a verb missing. Do you know what I mean?
I'll
Which
definitely, I don't have it open with me right
Is
now,
this
but
3.2?
I've made a note to review 3.2. So I'll
Yeah.
ensure to do that and make sure that it's as clear as we can make it.
Yeah, thanks, because I
course.
don't know what the intent is, as is. The other question I had, so if it's a person, not somebody in an authority who gives a notice, and I assume like asks the name of the person who seems to be trespassing, I'm not sure there's anything in the law that indicates what that occupier now has to do in order to flag like the trespassing. Like I see
Right.
there's the offenses that are described and the enforcement and all of that, but I'm not sure. I might have missed it, but just in terms of if you're just a regular person, what are you supposed to do when
Yeah.
somebody, you know, trespasses on your
Great
own
question.
land?
So that would be a policy we could develop to support this land. So you would have to call whoever is the authorized person. So once this law is in effect, what would usually happen is then we make a notice saying this law is in effect. If you think somebody's trespassing, please call this phone number. And so
Okay.
in that instance, a landowner, if you said, hey, you know, John Doe over there,
Mhm.
you're trespassing on my property. They've now been considered to be given notice. So now they know they're trespassing. So then you go inside and you call the phone for KPS and you say, there's somebody trespassing on my land. I've told them they're trespassing. They're refusing to leave. So now KPS knows the legal occupier has given them notice. Those people are on notice that they're trespassing. So now KPS can show up there knowing that they can ticket them for an offense. They most likely would ask them to leave again, and then if they refuse to leave, would give an offense. But that would be an example where the legal occupier is given notice.
Okay. Okay, thanks for that. And my last question is, if I'm wondering, is the intent for this law to apply to a situation where, I don't know, somebody has built a building on a piece of land that they don't own, and they're, you know, they've built a business, whether it's a gas station, whatever, and they don't have a permit from council. Is this the law that is going to be used against that kind of behavior, or would this be something else? Or, like,
This law can apply moving forward, but it can't apply retroactively. And it's also something that would have to apply looking at things like your housing policy and those pieces. But most likely, what that would mean for that example would be that those people, you know, we've now already given the okay for a lot of things to have been happening by not having any laws in place, but now having laws in place, it could prevent for an trespass from ongoing. If that makes sense.
but I mean, if the council has never consented to having, like a building set up and a business happening, if there's never been like a consent to that by council,
No.
nor by
that
the province or the federal government,
for
I'm
that,
pretty
I think
sure that a law that the council would now enact could apply to to people who are doing that. Am I incorrect?
I have 2 points to make there, and then Chief Brand, I'll let you jump in. One, that would work a lot better if we have a land use plan, which I think is a priority in the future to get done. Because currently I don't think Conestoga has, a land use plan in place determining, what zones are for what land is for this, what land is for that. That's something we would need to look at, because a court would also then say, hey, this isn't really enforceable because what documents are in play saying that they can't do that already, right? So those are things that we all would look at together, but it's definitely, I think, in the spirit of the law that we're moving towards, and the up and coming pieces, like hopefully a land use plan that then would prevent that in the future for sure. Chief Brandt, do you want to jump in?
Yeah, I would say, well, that part already technically follows under the land code. I think it's section 33.2 states that before any commercial, industrial, or not residential, but projects take place on Conestoga lands, essentially permission from the council has to be taken, and then other steps like environmental review if there's impact in environment and everything like that. So
Oh yeah,
regarding
great. That's great.
yeah regarding the Conestoga land base, the federal lands that are already purchased post 90 and haven't been allocated under OCA letters, that part still applies and everything like that. So like yeah.
So there's some powers, yeah.
Yeah, so there are buildings in contravention of that currently existingly, and that ties in also to Wendy's question. She had how does the federal land base fall into this law? The federal land base is Conestoga lands that simply haven't been allocated by OCA letter. So the possessor, I guess the authorized possessor is the one assigned to manage it, which is council on behalf of the Mohawks of Conestoga. So anybody who would want to build something on the federal lands would have to get the okay of council to do that, and that's what I was mentioning to the other one. It's section under 33.2, I believe.
Okay,
Awesome.
I don't have the land code in front of me, but is there like consequences for breach of that provision? Do you know?
I was looking at it recently. I don't recall. I
No,
don't
I don't
recall
think
if
there
there's
is.
actual. Yeah.
Usually the land code doesn't deal with enforcement or penalties, but considering there is that provision, the enforcement of penalties could be what we have here in the trespass land. The trespass piece, yeah. There's an argument to be made that could be enforceable between the land code and the trespass law. Mhm.
Wendy's asking, are you saying that the buildings that are already in place are affected by this law once into effect? Or once it comes into effect? Essentially, yes. Well,
Currently
in a way,
they're already affected
yeah,
under the land code, right?
yeah.
Okay.
So it's complicated and challenging, and you really need like a well-oiled number of pieces of the puzzles to make things substantially different when it comes to the business issues, right? But though I think it's an important flag for Wendy's question that those buildings are already, quote unquote, in contravention of the land code.
Yeah. It wouldn't make sense to me to pass a law that explicitly pardons transgressions that already happened. I mean, that's not the
No.
point of doing this.
No.
I am going to.
Yeah. Yeah, it's not like provincial laws where if you've been trespassing for like 10 years somewhere, the person who owns the land ends up kind of relinquishing it, and the
Yeah.
person who's using it acquires it. So this doesn't happen on
Yeah. There's no
reserve
subwater
land or
rights.
First Nations land.
Yeah.
So I guess, and I'm raising this because there's so many trees that have been cut and the landscape has completely changed on the main road. And to me, that's like an urgent matter to address. So when I saw this trespass law, I was hoping that it would, deal with that. But if it's not the
Here
case, if it's more under the
also,
land code, then I guess it's a question of enforcement at this point.
well, and you will also like the land protection law.
Yeah.
That's the next law, because that would be something, anything causing
Okay.
harm.
Okay.
It's not permitted, could be impacted there. So I am going to try to go through these pieces, as if we only have 55 minutes left and we have 2 laws left. But thankfully, I think we covered most of the more complicated things like enforcement, and they're the same. But the first
Okay.
piece here is the emergency measures law. And it's designed to protect the community in emergencies or disasters. So this one has a very narrow scope. Most communities have gone ahead with an emergency measures law lately as a result of the pandemic, right? So what happened was there was an emergency with the pandemic, a health emergency. Communities ended up shutting down. Some communities were really impacted, especially being rural, remote, and not having losing some access to their necessities like food, things not coming in as quickly because of the lack of transportation. So having an emergency measure law is empowering the council to act in the event of an emergency or disaster. Now, that can sound scary. It is not as scary as it sounds because it's very much limited by what we define as a disaster or emergency. So you can't misconstrue or take a broad approach in what you think a disaster or emergency is. A disaster means an urgent or critical situation that is resulting or may result in the harm of safety, health, and welfare, or widespread damage to the land. So it has to fall into this definition or category to be considered a disaster. It can't just be, oh no, this is a disaster, we're going to enact a state of emergency. No, there needs to be a real urgent or critical situation happening that's going to cause harm. An emergency means a present or imminent situation that requires a prompt action to prevent harm or damage to the land or loss of life, damage to health, safety, or welfare of the members. So, for example, like a flood could be considered an emergency or disaster. Health and safety means physical state, mental, and social well-being. And again, an authorized person is a term that we've looked at. It's somebody appointed by the MCK. So declaring a state of emergency, the MCK could declare a state of emergency if a disaster or emergency occurs. Thinking back to those definitions, this is done by bound council resolution, has to be posted publicly via website, social media, email, and has to include the description. So the description of what's going on, the date, and the duration. So it cannot be an open-ended piece. There has to be a date that this emergency is ending. It has to include the affected areas and any contact information or emergency action. So who's the authorized person? Let's say there was some fluke health crisis, you needed to make emergency temporary hospital shelters. You have to declare a state of emergency, and you've appointed an expert doctor on rare diseases to be the authorized person, and you've provided their contact information. You also have to have the duration date. So you'd say this state of emergency is only in effect for 30 days. The next piece is emergency measures. So what are the powers under this? So subject to Section 4, once you've declared the state of emergency, you can implement emergency measures limited to the measures necessary to mitigate or address the emergency or disaster. So it has to be justifiable to mitigate whatever's happening, whatever that emergency or disaster is. So there's a lot of limitations here. Limited on your definition of disaster emergency, you're limited on the duration of the disaster emergency, and you're limited to the measures have to be necessary to reduce or address whatever those disasters or emergency is. So it could be things like travel, it could be evacuations, it could be providing services or supplies, it could be setting up shelters, hospitals, repair services, or mitigating environmental damage. Ending an emergency measure ended by passing of a resolution, and that has to happen when the emergency or disaster ends. Again, it all gets posted publicly, and so everyone would be informed. Offenses. So if you were, continuing to do something prohibited under this emergency measure as a result of trying to get to, let's say there's a tornado coming, we're trying to evacuate the elders, somebody's having a big party and blocking the roadways for us to go and get to the elders to evacuate, you could be ticketed under the emergency measures order. So same offense and penalties as the other law. Quick summaries, it really is about enabling a rapid response and trying to protect people, land, and property, and emphasizing responsible use of authority. So defining some really strict parameters on when and how these pieces are able to be enacted and used. Any questions on the emergency measures law? I also do want to note that if you're looking at these laws and you have specific concerns around clarity, you can also send emails to communications@kanesatake.ca. That gets directed to me, and we'll make sure that those are corrected for the next draft. Okay, well, that one was very quick. Land protection law. So this one, I think, touches back on pieces around cutting trees down. This is a really fantastic law. I think it goes above and beyond just the spilling and the, dumping issues, and really thinks about, how to protect your land and territory for generations to come. This applies to everyone. There's some big key definitions here that you can read through, but the big one here is contaminant and pollution. It means any solid, liquid, gas, odor, chemical, heat, sound, vibration, radiation, or a combination of any of those directly or indirectly, which may cause harm to the environment or ecosystem. So like cutting down trees may be that. Interfering with the use and enjoyment of Kanesatake land. Cutting down trees may really interfere. Causing serious or significant damage to the environment, adversely impacting health and safety or welfare, dumping any waste, spilling, discharging, releasing, or depositing any substances that could mean that could be harmful to human health or the natural environment. So it's a big definition, but it's to encompass, all of these different ways that we don't always think about that could cause harm to the land, like things like sound and vibration. That tends to fall off our radar when we're thinking about it. But of course, sound and vibration can absolutely destroy ecosystems, which we also have defined in this law. We defined ecosystems as interconnected living systems. So we wanted to take a holistic approach in thinking about, what an ecosystem is from a Kanesatake perspective. We also defined habitat as spaces where aquatic or wildlife species live. So both, we didn't want to leave our aquatic relatives out of here. And we've defined natural resources, so soil, minerals, plants, etc. Prohibited activities. So again, it's a little bit of a simpler law compared to, like, let's say, trespass in just the terms of what's prohibited, but incredibly impactful and could mean, a multitude of things. So prohibited purposes, subject to permits, which we'll talk about in section 5. It's an offense to engage in any or all conduct that introduces the potential to introduce contaminants and pollutions that may or will likely cause damage, harm, pollution, or other related impacts to Kanesatake land. So a little bit of a broad definition, but please remember to go review the key terms and definitions, right? Like contaminant and pollution is defined, and it's really about if we're introducing a substance or a sound, radiation, odor that is causing damage to the habitat, the ecosystem, or the land, then it's an offense under this act. So that being said, a big part of the reason this is done is because any of this damage also impacts our Section 35 rights, right? Which are our Aboriginal and treaty rights, things like hunting and fishing. If we're damaging the land, we're also damaging our Section 35 rights. So that being said, lots of things could fall under prohibited purposes that could cause harm to the land, right? Like building a new home or, having so many fireworks that you've destroyed an eagle sanctuary. So there is a permitting section. MCK may issue permits by resolution, so it would be by a BCR that could authorize specific activities or conduct that would be otherwise prohibited under this law. We're able to imply some conditions and restrictions to mitigate the harm. So let's say the tree cutting, people's, you have a CP for that land, you're doing X, Y, and Z. It's going to cut down in eagles. You'd want to cut this tree down. It's going to cut down an eagle nest. You should probably get a permit to do so. The condition restriction may be that they're going to call wildlife people and they're going to come rescue the baby eagles from the tree, and then therefore you can cut it down and not kill the eagles, right? So that's how that would play out in terms of a permit. Complaints and investigations, so section 6 and 7. Any person can submit a complaint to the MCK. So process, what this would look like, to be determined, because that would come into play after would be in effect. And what that means is maybe it will be an online form. So maybe there'll be an online form on the website where you could anonymously submit a complaint. And then that would go to the MCK to be reviewed. I'm just gonna take a sip. My throat's running dry. A complaint must include information like the suspect's information. So if you were watching, my aunt cut down trees on her yard and you wanted to submit a complaint because you saw those baby eagles and they weren't rescued, then you would want to include her name, the address, what she was doing, the location, and then the authorized persons or the officers have the authority to collect any evidence they need. So once those complaints are received and we go, oh, well, look at that, Saber's aunt cutting down trees with baby eagles in them, we better go check that out. And then they're able to go and collect samples of, the soil or evidence or a witness statement. Upon receipt of all of this, so after the evidence was collected, the complaints received, then the evidence collected, MCK would be doing the review to determine whether or not an offense was committed here. The offense section, same as the other ones, it's a summary conviction. So part 27 of the criminal code, imprisonment up to 2 years, less a day, community service, fines up to $5,000. Usually what this means is, it's a very big spectrum. You could have a fine from $100 to $5,000. You could see no imprisonment. You could see community service, or if it was significant enough, you could see imprisonment up to 2 years. And again, it will be heard by the Court of Quebec or a justice of the peace or courts if we're able to establish one down the line. Commitment to future generations. This is really about ensuring there's some long-term ecological protection. A couple pieces for just all of the laws as we wrap up, and then I'll take questions on land protection. But all of the laws are subject to the KLMP adoption process. Laws can be repealed or amended via community processes under the KLMP. Language rights are respected, which means if the law is challenged and there's the interpretation's not totally clear, then the Ganyagahage perspective would be considered the supreme way to interpret the law. The law remains valid even if parts are invalid, which means sometimes laws go into a challenge where they say, that word needs to be striked out, right? That means that sentence is invalid, but it doesn't mean the whole law is invalidated. Effective, this is an important key piece because once we go through the KLMP process, which is we're just in the first stage, the initial draft has been released. We're getting feedback on the initial draft. There will be, an announcement of next steps once we're able to gather that and review the laws from that perspective. The laws aren't effective until the final stage of the KLMP, and that means they have to be published on the MCK or First Nation Gazette website. Sometimes I think there's misconfusion around what effective means in this term. You can't just go ahead and say, oh, these draft laws, we're publishing them to the First Nation Gazette and now they're in place and we're running off to the races. No, they are subject to the KLMP. They're just effective once they're published post-adoption. So those are some pieces there. I will leave it open for any questions regarding the trespass law, we covered the trespass law, but the land protection emergency measures, if you have questions on that, I'm happy to take them now. Then if not, I'll go through a couple more pieces here. Hi, I see hands up.
Yeah, thank you. It's just, I don't know if I've got it in front of me, but I just find that the one provision, I think it's maybe section 5 where, you're right, I think it's the prohibited purposes.
Sorry, is it
Is it
emergency measures
4.1?
or land protection?
No, sorry, the one you just reviewed, the land,
The land protection. Okay, perfect.
yeah, I can't find it. I don't have it in front of me.
No problem.
Oh, land
Prohibited
protection. Okay, I
purposes.
think I've got it. So it is for prohibited purposes 4.1, right?
Yeah.
Yeah. So I guess my concern was because we were giving the example of the cutting of trees to build, buildings and infrastructure without permits. The concern is that the prohibited purposes here seem to be limited to conducts that introduce contaminant and pollution that will cause harm.
Yep.
But that's not necessarily the case for the example that I was talking about earlier. It's not necessarily introducing pollution or contaminant. Like there's,
Okay. For extractive reasons, you mean like instead of adding something to the environment, they're extracting from the environment instead, I think is what you're getting at.
well, yeah, because I do appreciate how it says at the beginning, interfere with the use and enjoyment of Ganesidague land. So it's not just a question of preserving, like avoiding pollution, contaminant. It's also just like living up to our traditional role as stewards of the land, where and not just protecting the environment, but just protecting the rights and protecting of all like Mohawks of Ganesidague and knowing that you can't just decide that you're gonna cut out trees to do something that will benefit you alone, right? Without a permit. So
Yeah.
I've yet to look at I think it's a land code that Chief Brand mentioned earlier.
Yeah.
But I guess it's very important to me, and I know it's important to a lot of people in Ganesidague that this be addressed, how the landscape is completely being changed.
Yeah.
Yeah,
So
I really appreciate that perspective. I think that this law is a narrow law. It gives us some ability to prevent that. So, for example, the tree piece, that would be a sound or a vibration that's being introduced into the environment that causes harm. So there's some technicalities where it could fall under the contaminant and pollution, but it also, that may be more of if that's if we find this is effective, but it's not being totally effective to that piece, that could be an additional law, right? Or policy that we're looking at specifically around like building measures and preventative measures when it comes to development, right?
Yeah. I think like another example I think I can one is like say we had in the past people that would essentially be selling topsoil or soil and digging up hills and digging up parts of the mountain and stuff and selling it outside of the community. Yeah, I could see how something like that seems to fall outside of this bounds, but it's still having
yeah, it
it's
has
an
an
extractive
impact.
process. It's an
Yeah,
extractive process taken away.
Yeah.
that's it. It's for sure it has a direct impact on the environment, but I think it goes even further beyond that, like I think of, let's say we take the city of Montreal. What's going on in Ganesidague is the same as if I go to, I don't know, a park that we have, like where the kids play, someplace in Côte des Neiges or whatever, and I just start building a store and I start selling things that I don't have a permit. Like it's probably going to fall under the criminal code. Like it's not just environmental, there's way more to it. So I guess I'm hoping that the council will have the power it needs to have have all community members respect all of our rights, you know.
Yeah.
Yeah.
I'm hoping that happens too.
Yeah,
Mhm.
such
Yeah.
great perspective and such a great voice to hear. These are like our first bundle of laws. We've kind of been operating with none. So this is
Mhm.
these four really are, the baseline laws that you then can build up on and go, okay, well then we also need these very specific laws, or we need these very specific policies. But this really provides that stable base to
Mhm.
to move those waters forward.
Yeah, for sure.
Yeah.
Thank you.
Wendy had submitted another or statement.
I do have it over here.
Oh, awesome.
Okay, I'm concerned by the wording with all these laws, whereas it states that law can be repealed or amended from time to time through community approval, or shall periodically. The time frame is not clearly identified. It can be misused and misinterpreted. So it has to be done through the KLMP. So they can be repealed or amended through whatever the standard of the KLMP sets out, which the KLMP sets out whatever is in the land code and the governance code. So the land code or governance code, Brant, do you remember off the top of your head? I got those two
What was
pieces.
that?
Is it the governance act or the land? It's the governance act that sets out the community approval process, right? I'll pull it up.
You have me second guessing myself. I'm actually not sure.
I know.
Yeah.
Sometimes
Yeah.
I've looked at these documents too much.
Yeah.
But the KLMP just reiterates what the community approval process could be from our already pre-existing codification. So the Governance Act or KILGA, the land code. These pieces detail what community approval include, and I believe there's three. The land governance code. Thank you so much, Justine. So in the land governance code, it states what the community approval process is. There's three different streams. It could be through workshops, it could be through community engagement meetings, or it could be through a ratification vote. So there's options that we've set out in the governance code that was predetermined from this mandate. We then just took that and made it clearer and set a higher standard in the KLMP. So you can review the KLMP for those pieces, and then all of the laws are subject to the KLMP. So we cannot willy-nilly divert from the governance code or the KLMP in these individual laws. They all circle back and work together. Anything to add there, Chief Brand?
Nope. Nope. I'm good.
Okay, amazing. Okay, so in terms of next steps, we've been gathering feedback on these draft laws. We now basically will go through a period where I take everybody's comments and questions. I go through the laws with those, concerns and make those edits. My senior counsel reviews those edits, make sure they make sense, and then we share them back to MCK, and then they decide the next steps as per required under the KLMP, which could be more community input through the next set of drafts or a ratification vote. So those things would have to be announced, I think, within the next 2 weeks of what the next steps would look like, and it would lay that out in accordance with the KLMP. That being all said, too, I think it's an important note that we have a One Feather platform set up, or MCK has a One Feather platform set up that would be great if you guys registered too, because it's an ability where you could update your mailing information, your cell phone, your phone numbers, your emails. So if you're not getting access to, the mail outs or the notices directly, once you registered on here, you would be able to keep those updated and keep in the loop a little bit easier. So that can be done at onefeather.ca/nation/Ganasatake. And I think Justine's going to drop the link in the chat. Yes, Chief Brand, all you.
Yeah. I'd also like to say, I think it was Wendy mentioned she's no longer getting mail outs. If you happen to tell the post office that you don't want to get like flyers anymore, they're not including the MCK mail outs as well. So you might want to check with the post office on that if you're not receiving anything from us.
Yeah, and Justine's gonna throw the link in the chat there. And that's really it from my side of things. Maybe I'll hand it back over to Chief Brand with their
Well,
closing
yeah.
reflection, or if there's
I think
more questions.
Wendy asked if we can give her a call for a Q&A.
Oh, great, yeah.
Thanks for calling me.
Yeah, of course. I'm sorry that there's some tech difficulties.
I don't know what it is. It's okay. I've heard so much. It's a lot to take in a 2-hour session. It's a lot to think over. I mean, it's. I don't know, like if I could, if there was if he required a decision or a comment or things like that tonight, like I would have to like go over this like so many more times and have so many more conversations. So
yeah, please, I really encourage you to do so. And I re-put the communications email in the chat.
Yeah.
So take some time to print them out, read them over. You can send any comments, questions you'd like, and we'll review them. Absolutely.
I'd just like to go back to something that was said earlier. So we talked about the federal lands that do not have OCA letters, correct?
Mm-hmm.
We talked about buildings that are already established. And I'm just going to ask again to make sure that I understood correctly, is these people or these buildings or individuals are going to be affected when you pass a law after the fact?
Well, no, technically they're already in contravention. But there's it's under the land code that they're in contravention right now, except that under the land code there's no penalties. With this law passing, they also happen to be trespassing, and there's penalties outlined there. So they wouldn't just be in contravention of the land code, they'd also be in contravention of possibly the trespassing, possibly the land protection laws. And each day that they continue to be or aren't working to rectify that would be an additional instance.
And have letters been sent out to advise them of such, like to let people know that they are against the law that you just mentioned, that there's penalties, etc. Has that been done?
Not explicitly.
So how can you?
People have been warned. Many people have been, and the community has been told many times that building on federal land is prohibited. There was in 2016 during the election. Then there was a referendum being held on whether development on federal lands would be allowed, and the community said no. And a BCR was passed with regulations there essentially saying that any development on federal land is prohibited. So,
and was there a consequence to that in what was signed? Was it outlined what the consequence was?
no.
So like legally, how are you going to implement that?
The law would be passed, and then they can be served with a notice.
Yeah. I can jump in here for a brief moment. So between the date of when the law is passed is a different date of the effective date. So once the law is passed, we go, hi, this law will now be in effect as of this date. And then there's usually provided a grace period for people to become compliant. So when that notice is given, so we can't give that notice until the law is in effect. So once the law is in effect, we can then go, hi, this law has been now adopted. You have the next 12 months to become compliant in this law, or the next 90 days to become compliant in this law. So it just depends on the risk mitigation.
So you were saying earlier that people would have to put a request into, I'm going to say council for the lack of I don't know which commission or whatever. People would have to actually put in and ask permission to use the land that they're already using.
Well, it's they were already required to be asking permission and they didn't. There was no.
Just,
If somebody
I
comes and
just want to
builds
make sure
something
that's
on
clear.
my. Yes, but if somebody comes and builds something on my front lawn and doesn't ask permission one day and then the next day they ask my permission after it's built, I mean, it doesn't change the fact that they didn't have permission to build it on day one.
Okay, so seeing that a lot of these buildings are already up, what are you gonna tell them to do? Bring them down? Who's gonna decide what stays up and what comes down?
I mean, the law.
Well, and again, that specific piece is, very complicated. So the issue of trespass specifically, it would have to be done in line with whatever the land code says. And it would also have to happen in relationship with a land use planning. So right now, the biggest issue is we wouldn't be able to say, hey, these need to be moved, and not say they're able to be moved here, or they're being removed and you're not able to reestablish these pieces. So that would be a more lengthy process. Some of these more complicated legal issues, there's no clear, immediate distinct resolution. Like, it would have to go over a notice process, and there would have to be some pieces that would be ironed out. The trespass law really relates to that legal occupier. So we would have to work and to see, are those people legal occupiers as per your housing policy? If they're not legal occupiers as per your housing policy, what does your housing policy say about becoming a legal occupier, right? And so right now, if you're not able to apply for an OCA letter, they would need a process to be established saying, well, you can't say you're evicting us with no ability to reapply for an OCA letter. So these are very complicated pieces when you're talking about removing businesses or demolitioning businesses, but it would be very easy for us to prevent that happening from the future with these laws. So those pieces would have to be ironed out if this law if this law were to be passed. Then how that notice would be given, that's where those pieces would be outlined. And because this law hasn't been passed, we're not able to speak to how those notices would be given. But these are all, information we have to come back and look at all of the housing policies. What percentage of people would be in contravention of the land code, and what that looks like as a threshold.
So anybody that doesn't have an OCA letter is in violation.
No, I don't know what your housing policy says, so that it would have to be looked at in relationship with the housing policy.
Right?
To my knowledge, pretty much.
Okay.
But the housing policy only really applies to OCA letter lands. It was written with the intent that it applies, that it deals with the OCA letter lands.
I feel that the problem with this is always been because of council. Like, how long were the houses unoccupied before the people said, hey, we need places to live and we're going to take over these houses? I feel that a lot of the problems that are happening, people that don't have OCA letters and, fighting to get repairs, it took forever for people to be able to get repairs. All this because back then, council didn't necessarily do what they could have done. People were paying rent, and then that closed, that department closed, and then nobody continued to, or as far as I know, nobody continued to pay rent. So I really feel like, we're at the end of the line here, but the problem goes back many, 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 many years, where there was no action taken or implemented. So now we have all of this. So there's like, does that mean, how has it affected people that are in the homes there, that are in the federal homes as it is? How does it affect them? Or does it just affect businesses and not the homes, the houses? And where's the fairness? Like, I just, this whole thing about I just feel like this is huge. And there's a lot of things that are going to be stirred up with all of this, because you can't just apply it where you want to. You have to.
There has to be equal application.
Well, absolutely equal application, but I just feel like All right, I'm gonna keep my opinion to myself now because I don't wanna,
Well, I really would
Points at
encourage
any-
you to send an email too, right? And if you, I personally would really appreciate documenting all this because this is all really good information, whether or not these laws move forward as is, or in the future mandate, having that information is always helpful.
that just, this is very surreal right now for me, but anyways, okay, I'll keep you on just in case I have another comment.
Okay, great. Yeah, that's perfect. I believe we have hand up.
Yeah, hi, it's me again. So I am looking at the Ganasatagi Interim Land-Based Governance Act, which I think you were referring to earlier. It provides for a land use plan. So like it says, the Mohawks of Ganasatagi will adopt a plan that establishes general policies governing land, etc. So do we have that in Ganasatagi or no?
We only
No,
have a
not
land
yet.
code right now.
Okay.
Sorry, Saber.
Yeah, so that's, oh, I was just gonna say that's definitely a priority is the land use plan.
Yeah.
This year has been, I think, the ethics commission, the lawmaking process, now the laws and the land use plan. Unfortunately, the funding agency for land use planning only divvies out so much funding per year. So we've been trying to work with them to be able to make
Okay.
something happen.
Yeah, because it is like it, as was said earlier, it is under the act that it says, you know, the Mohawks of Ganasatagi may prosecute an offense committed under a Mohawk law in a court of competent jurisdiction, and then the Mohawks may adopt the procedure applicable under the Contraventions Act, which is a federal act for the prosecution of contraventions, subject to the necessary modifications. So we already have that. That's already enacted. So
Yep.
just need the land use plan. But I'd be surprised if under the Indian Act there wasn't already something in there that prevents this kind of behavior and trespassing, because the council is really the sole authority, and you know, with respect to lands
So the way
in the
that
communities.
Act deals with that is by under, I think it's section 87, empowering nations with the ability to make laws as well. So that way,
Mhm.
we can.
But then if they don't make those laws, usually the law of general application is going to apply. They're not supposed to be a vacuum.
No, but
There is a
unfortunately,
bit.
trespass is a provincial jurisdiction and not a federal jurisdiction, and so that's where we get into hot water, right?
But then, I mean, there are always some provincial laws that apply on reserve. So if the MCK doesn't have the, you know, the applicable law to deal with certain things, then I would assume the provincial laws would apply, depending on whether it's under federal or provincial jurisdiction. Like if it's an environmental issue, it would be under provincial laws, I understand. But I don't think there's a possibility of like not being any jurisdiction applicable
Yeah.
to
I,
you know,
I
the
get what you're
lands
saying.
here.
Yeah.
I get what you're saying. The problem is what's in the law and what's actually enforced when it comes to the province and the feds. Sometimes, you know, getting them to enforce the laws is not easy.
Yeah. Yeah, that I get. I understand the whole enforcement thing is a huge issue, especially for Kanesatake, because of everything we've gone through. But I'm just saying I'm pretty sure there's a law that applies even if the MCK hasn't adopted one.
Probably.
I just
But it is a
Saber?
great flag. So provincial laws are not applicable on reserve unless the reserve adopts a provincial law. So oftentimes then what a nation does is if they are in an agreement with a provincial law is they'll mirror the provincial law within their own law. And that's where you see this trespass law is mirrored from a lot of standard trespass laws. We don't take a big a creative approach to the trespass law. We're mirroring a trespass law that stands at common law, which means a provincial enforcement ability and means what trespass is on a provincial level. So that's the way nations are able to adopt provincial laws, are by passing their own laws saying that they uphold the provincial standard. But there's no
Yeah.
automatic application of a provincial law.
Well, I mean, if you look at Section 88, that's the general provincial laws application to Indians. So they do apply by reference. It says, subject to terms of a treaty or whatever, all laws of general application from time to time in force in any province are applicable to and in respect of Indians in the province, except to the extent that those laws are inconsistent with the Indian Act or the First Nation Fiscal Management Act, etc. So that's what this provision is about. It's that if the nation hasn't adopted their own law regarding a particular subject, then the provincial law that applies will apply until such time the nation adopts their law. So
It is a complicated piece for sure, as the majority of our provinces will not enforce or apply provincial laws because of just the contentious relationship between the federal and provincial jurisdictions. So oftentimes what provinces do is they go, Indians are not our problem. They're a federal jurisdiction. We are not going to enforce our laws within Indigenous territories or within or on reserve. So there's a conflict with just how a province approaches this as well. So although those pieces are documented, and that's a real reality for a lot of communities, even though so many communities adopt provincial laws and are explicit in adopting provincial laws, the enforcement of provincial laws is a very different scenario. So oftentimes they don't end up having a working relationship with the police, the local provincial police, and therefore then the laws are unenforceable if there's no piece there. So there's a lot of really big workarounds. The best approach we've had in our advocacy work as legal counsel is to advocate for the layered jurisdiction approach. And that's where what you see and why we take this approach is we say, yeah, here's one way we can enforce it. Here's another way we can enforce it. Here's our, inherent rights. Here's the Indian Act. Here's the land code. Here are these pieces. Like we want them all working, together. And then that way it really helps hold both the feds and provinces accountable to avoid their ability to go, well, it's not our problem really. So that's just to speak to a little bit more of the overarching, legal approach as to why we take
like
this.
I understand, that there's no police force and community would need an agreement with the SQ to have that enforcement, but I think that not having those laws doesn't prevent, for example, the council from suing someone under the laws of Quebec.
That's
Sorry, so we're going to start suing our people using a Quebec law? Like, are we living in Ganasadaga?
well, that's one question. That's a jurisdictional question, sort of. But right now, like I'll give you a concrete example. An injunction has been brought against people that were dumping on property along the water along the shoreline, and very I think about 15 or so individuals. Some of them were responsible for making the decision to do that. Some people got caught up and everything like that. But the actual injunction is being carried out by Quebec and everything, not MCK in this instance, and they're relying on Quebec waterways regulations to do this. The only problem is they recently changed their laws regarding floodlines, and that sort of plays into it, but it begins to encroach on Ganastaugian lands and everything, how it relates to the center of navigable waterways are federal jurisdiction, then a certain distance from the shore and into the shore are provincial, and then a distance from the shore is Ganastaugian land. but that new flood map sort of muddies things up and is causing concerns for council regarding jurisdiction and whatnot. So like we want like essentially it comes down to a question of, well, okay, the law is there, it is enforceable. It's enforceable, yes, if the province will accept it and everything, if they will accept to enforce it, or if we have the funds and the support to actually do a lawsuit in that case, which is not always the case. But then there's the political question of, do we actually want to rely on provincial laws as
No, and
enforcement on
yeah,
Indigenous land?
I totally understand. I mean, in an ideal world, we would not rely on even federal laws and
Yeah.
provincial laws. But it's just as Wendy was saying earlier, it's been years that there haven't been many laws applicable in Ganasatake,
Yeah.
and we have to decide what's better. Do we
Yeah.
have a land without any jurisdiction, or do we use what's available in the interim, which might be federal or provincial laws,
Yeah.
and in the meantime do our best to develop our own laws?
Yeah, I totally agree with you, but
Yeah.
like even utilizing Wendy's statement, like I think the way she meant it and the way you meant it are two different meanings and actually exemplify the difference in view on this very well. And that's unfortunately where the politics enters into it and everything, because you have the same situation, you have the same problem, but you have two different views on it and everything. So like unfortunately we're really stuck. And this kind of ties into the issue with what's perceived as low attendance for these meetings, is if we're looking for political support and we're having these things with a clear intention to fix things, but we're not getting that political support, where do we take direction from? Do we say, well, like I said, well, I know at least 300 people in the community that voted for me knew that they wanted that I was running to fix the environmental problems. So do I take that as, well, they would support this, or do we take the poor attendance as being possibly people's uninterest or disagreement with this? Or does the poor attendance mean that, well, people are like, well, why are you bothering me with this? Your guys' job is to deal with this, or like any other multitude of ways that, poor attendance at this meeting can be interpreted. It doesn't mean anything because nobody said anything. If there's nobody said anything, there's no meaning. I mean, like that's sort of the catch-22 council stuck in right now. We want to fix this. There were provincial laws, but it was not really viable, so we're going this route.
No, definitely. I mean,
Yeah, it's garbage.
yeah.
It's garbage.
My only point was really to say that I don't think I'm convinced that just because these laws that we're now working on have not been enacted in the past, that there was nothing that could be done about, the squatters, the people who were encroaching and all that.
Yep, I agree.
Mm,
I think there was plenty of ways to do it, but there was no political will.
Thank you.
Saber.
Thank you. Yeah, I unfortunately have to drop off, but Wendy, I'm gonna have to hang up the phone call, but I don't know if you guys want to continue to chat for a couple minutes, so I might have to leave you to it to do the wrap up. But I just want to reiterate that the communications email is in this. I know there's a lot of information, a lot of facets, a lot of considerations. Don't worry about doing an info dump about your comments, questions, or concerns. I'm happy to review them. I think, any thoughts are worth merit at this point. And we'll be making an announcement in terms of next steps in the coming, I think, 10 days-ish of what that will look like for the next phase.
Yep.
Yeah.
Okay.
Just
So,
don't hang up on me.
No,
I just
okay,
wanna say,
perfect. Yeah.
just listen, I listened to all of this. I don't know if all the laws are perfect. Like I said, it's a really quick presentation when you have to look at this.
Yes. Absolutely.
But let's say that some people are not in agreement with some of the laws that you placed. Who's going to have the final say on this? And how are you going to do it? Anybody?
I think we'll follow the KLMP. That lays out the KLMP and the land code lay out what the regulations are for passing these laws. So we'll follow those. Well, we have to actually. I mean,
Yeah.
if we didn't do that, we'd be breaking the laws, and then they'd be invalidated. So
I just hope that at the end of all of this, that I don't know. I just hearing all these provincial laws and the comment about like suing our own people on the land on the Gunnisondaga land. I just it's so upsetting to hear that we're there. You know what I'm saying? It's
we were there a
upsetting.
long time ago. As soon as the first person grabbed some land, started cutting some trees in the pines, we were there. As soon as the first person started, letting companies bring in contaminated landfill, we were there.
Right. Well, I'll continue to read all the documents. Thanks for your time. Thanks for the presentation.
Yeah. Are we good to close up or anything else?
I think that's it on my
Yeah.
end, but yeah, stay.
Thank you.
Yeah.
Yep.
Yeah.
Likewise.
No,
Thank you.
thank
Very
you.
nice
Thank
hearing
you.
from you.
No,
Thanks
Anna.
everyone.
No, no.
Anna.
Yeah.
We'll be in touch tomorrow.